So we don't have to tell immigration about that, do we? Hi, I'm Julie Kruger. I'm the owner of Kruger Immigration Law, a boutique immigration law firm headquartered in Buffalo, New York. And this is a common question that we have from people contacting our office about their immigration cases, where they've got something in their past that they don't want to tell immigration about. Because they're worried about what the effect of that is going to be on their immigration case and whether or not they're going to be allowed to enter the United States or get that green card or get the work visa that they've wanted to apply for. They're concerned that this thing that happened in their life is going to come back to bite them again now. And they just think, well, if we don't tell immigration about it, how are they going to know? And then it won't be an issue. So that's a terrible idea. And we definitely advise against that. So here, I want to give a couple of examples of some of the things that people are hoping don't come up as part of their immigration process and that they can just avoid talking about altogether. So one of the things that people hope doesn't come up is past criminal convictions. And this is something that definitely needs to be disclosed. Whether it was an arrest that didn't lead to a conviction, whether it was a conviction for something very minor that was maybe only even a violation or a misdemeanor, whether it was a conviction that later got expunged or pardoned even. The US immigration system wants to know about it and you need to disclose it. On most immigration forms, whether it's ESTA, whether it's the DS-160 for a non-immigrant visitor visa, for a work visa, the DS-260, the immigrant visa application, your application to adjust status, your fiancé visa application, any kind of immigration application, US immigration system wants to know if you have any criminal history. So you need to list whether you've been arrested, where it was, what the date was, what you were charged with, what the ultimate outcome was, and what the sentence of the court was. Did you have to pay a fine? Were you sentenced to probation? Did you have to serve any jail time? Whatever it was, you need to disclose that on the immigrant visa or whatever, on the immigration application that you are filing. So that is one thing that people are hoping doesn't come up. I think maybe if I just don't tell them, they won't know about it. And that's the other thing to know for sure. The US shares criminal records with many other countries. So the idea that the US isn't going to know about your criminal conviction, first of all, give that up. They're probably going to know about it. So when they're asking you the question, and especially like during a visa interview and they're asking you, or during your inspection and admission process at the border or the airport, they already know the answer to the question and they're wanting to see, are you going to lie about it? Are you going to make this even worse by trying to hide it now? So definitely disclose it. And then, of course, the reason that people don't want to disclose a criminal conviction is because they're afraid that it is going to bar them from coming into the United States. And there are absolutely many crimes that create bars to being able to enter the United States. Anything that is going to be considered a crime involving moral turpitude, basically a bad act, that will be a bar, a lifetime bar to getting a visa or coming into the United States. And so that crime involving moral turpitude, bad act, can be, even something minor. It can be minor thefts. It can be, major things. It can be all sorts of different things. Minor drug convictions can cause problems in coming into the United States. And so you need to know in advance, your criminal history, and you need to know what the immigration consequence of that criminal history is. So if this is something that is in your mind, you have ever been arrested or cited or detained in any way by any law enforcement anywhere in the world, you should talk with an immigration attorney before coming to the border, before filing your visa application, before going through whatever process immigration-wise you are going to go through. Talk to an experienced immigration attorney so that they can help you determine what are the consequences going to be. How do we list this on the application? Let's get the right documentation. And then if it is something that creates a bar, are you eligible for a waiver? There are many waivers. There are exceptions for when something is very minor in the law. So, there are things that you can do even if you have a criminal conviction that bars you from coming into the United States. But you need to know that in advance. And you also need to know in some situations, there is nothing that you can do and you just won't be eligible for that visa and then you'll know that in advance, and you will save yourself the time and money and the heartache of going through that process to ultimately get denied. So definitely reach out and speak to an immigration attorney about your case, someone who is experienced in analyzing the consequences of having a criminal conviction and what that's going to be on your immigration status. So that's one thing that people are worried about, think maybe I just won't tell the border and they won't know about it. Definitely they will. It needs to be disclosed. May have consequences. Talk to an immigration attorney. Another thing that people are hopeful that maybe if they just don't mention it at the border or the airport or on their visa application, it will just be forgotten and go away and won't cause a problem in their case, is previous immigration violations. And this can be a whole range of things, from having lived in the United States illegally, maybe came in legally but overstayed your status in the past, came in illegally and lived in the United States, having been in a deportation proceeding before, having used somebody else's green card or social security number to work, having committed fraud when you came into the United States for an immigration benefit. There are all sorts of previous immigration violations that have happened to people, and that they, maybe were years ago, decade or 2 decades ago sometimes, and that people think, well, if I just don't mention it, how are they ever going to know? I'll just leave it off the application and I'll come in and it won't be a problem anymore. That was a different person at that time. I'm a different person now. I've learned my lesson. I'm not going to do that again. So why should I have to bring it up again? So this can cause huge issues and is a huge mistake that people make because it creates a new fraud, creates a new problem. So if you have previous immigration violations, this is something that, again, needs to be disclosed on your visa application, your adjustment of status application, or whatever immigration application you're filing. That will need to be disclosed. And it will need to be explained, the circumstances, what you did, when you did it, why you did it, all of that. And it may have consequences long-term for you. It may lead to bars to coming into the United States. If you were illegally in the United States for more than 6 months, that can be a 3-year bar to coming back into the United States. If you were in the United States for more than 1 year illegally, that could be a 10-year bar to coming back into the United States. A deportation order can be a 10-year bar to coming back into the United States, and immigration fraud can be a lifetime bar to coming into the United States. So this is something that, again, if this is in your history, you need to talk to an immigration attorney, an experienced immigration attorney who handles complicated cases, who can talk you through what you did in the past and how it's going to affect your case, where to list it on the application, what problems it's going to cause, is there a waiver available for you, are you still going to be eligible for this benefit, or should you give up and not file? You need to know all of these things in advance before you start your process, because the last thing you want to do is compound that previous mistake, that old history, with a new problem of not failing to disclose it and trying to hide it now. That's going to be considered a new fraud. It's going to make your case even more difficult. So you definitely don't want to do that. When you are speaking with an attorney, be honest. Be honest about what's happened in your past. That's the best thing you can do to allow the attorney to advise you properly, to assess your case and the best strategy for you and what can be done to help you. It's never a good idea to try to hide your past immigration history from your immigration attorney. And then, it's going to come out later at some point, whether it's during your deportation proceeding, during your naturalization interview years later. They're going to somehow match up your fingerprints later. You're going to admit it without meaning to later. It's going to come out. It's going to cause more problems than if you had disclosed it and been honest with your attorney from upfront, and then you could deal with it right from the beginning and figure it out and how to get it waived or move past that and deal with it now, rather than having come up in a way that makes it worse for you later. So those are 2 examples of things that people think that maybe they could just not mention at the border, and they'll just be able to come into the United States and it'll all get forgotten. They can put it behind them, and that actually failing to mention it can cause huge problems and for the long-term future. So if this is your situation, if you've got something that you're thinking like, maybe I just won't tell the border about that, or I don't want to talk about that, or I just want to forget about that and move on. This is something that you need to reach out to an experienced immigration attorney to talk to before you file that visa application, before you come to the border, before you submit your adjustment application to USCIS, whatever it is. contact an immigration attorney first. You can call me. My phone number is 716-393-9878. My email is julie@krugerimmigrationlaw.com. I'd be really happy to assess this with you and figure out the best strategy for you. I've been an immigration attorney for just about 11 years now, and I have extensive experience. We only do immigration. So I have extensive experience in this kind of case and handling people's complicated situations, assessing with them, okay, this is what happened and here's what we can do. Maybe it's something that, ultimately we figure out it isn't even a problem right now. The only thing we need to do is list it on the application, is disclose it. Tell them that, 2 decades ago you lived in the United States for a year illegally. Maybe that won't even cause a problem today. Maybe it will, or maybe you've got a criminal conviction that, again, isn't a problem and we just need to list it, or it does create a problem and you need a waiver application. We can deal with that right from the beginning. Or it could be something that completely prevents you from being eligible for your benefit, and you're going to want to know that too, so that you don't waste your time and your money filing for benefits that you're not even eligible for. You're able to move on and prepare the next stage of your life knowing that this wasn't going to work out. So give us a call. My phone number is 716-393-9878. You can email me at julie@krugerimmigrationlaw.com. I'd be happy to assess the situation with you and figure out the best strategy. Thanks.